As I speak, the case of Perry versus Schwarzenegger is slowly but surely winding its way through the judicial system on its way to what will surely prove its final destination, the United States Supreme Court. I'm sure that you, as I, await with bated breath the court's ultimate ruling as to whether the exclusion of same-sex couples from the marriage franchise violates the United States Constitution. My answer to that question is an unequivocal yes, but it is accompanied by one crucial caveat. If we, the people of the United States who sympathize with the LGBT community's quest for marriage equality, expect the Constitution and the courts alone to protect those rights, then ultimately the cause of marriage equality may not prevail. Refusing same-sex couples legal recognition denies them the equal protection of the laws to which they are entitled according to the Equal Protection Clause of the 14th Amendment to the Constitution. Now, let me make this clear. Such exclusion does not merely stigmatize a form of elective conduct. Rather, it targets homosexuals as a class for discrimination based on a personal trait that they did not choose and which they cannot change. This discriminates against and disadvantages gay and lesbian couples in a number of ways. It renders them unable to make crucial, potentially life and death healthcare decisions for their spouses. It cuts them off from benefits under their spouses' insurance policies and pension plans. In addition to that, it deprives them of the ability to have joint custody over children, as well as the ability to receive tax benefits, and so much more. Now, since the 1967 Supreme Court decision in Loving versus the state of Virginia, the High Court has made it clear that factors such as these, and many others, make marriage a matter of fundamental constitutional importance indeed. I would like to point something out where the case of Loving versus Virginia is concerned. Even in that case, the Supreme Court struck down what were then known as anti-miscegenation laws, laws prohibiting marriage between the races. Mind you, one of the arguments that could have been made, and I'm sure was made, against that court decision at that time was that, well, the individual liberty of the people affected by these anti-miscegenation laws is not totally trammeled. After all, whites are still free to marry whites, blacks are still free to marry blacks. Of course, that argument fell flat before the Supreme Court, as well it should have. Now today, when it comes to the debate over gay marriage, we hear a similar argument made. We hear that excluding same-sex couples from the institution of legal marriage does not disadvantage them because they can, a homosexual man can simply marry a woman, or a homosexual woman can marry a man. Now, this is even less compelling an argument in the context of same-sex marriage than it was in 1967 in the context of interracial marriage. The simple reason is that there exists, as far as we know, no biological innate characteristic that orients a person to feel an attraction to people of different races, a condition that they cannot control, in which they did not choose. However, that is the case when it comes to homosexual couples. A wealth of research shows that this characteristic is not a choice. How can we possibly continue to discriminate against the whole class of Americans based on something that they cannot help? Now, none of the other common arguments against same-sex marriage stand up to any level of scrutiny. The status quo finds no solace in same-sex couples' inability to procreate naturally. After all, the law recognizes marriages between the infertile and the elderly, does it not? The claim that gay couples cannot raise children optimally is swamped by a rising tide of research showing that their children turn out no worse than the offspring of their heterosexual counterparts. Religious disapproval of homosexuality does not form any legitimate basis for public policy. And what's more, the clergy is free to withhold its sanction from same-sex marriages if it feels the need. As for the argument in favor of preserving traditional marriage, well, it's difficult to see just how same-sex marriages would render opposite-sex marriages any less cohesive or any less sound on a long-term basis. If traditional marriage is under siege, then same-sex marriage is not the barbarian at the gates. So why then is the Constitution such an imperfect protector of these fundamental rights? Well, in recent years, the gay rights movement has made extensive use of litigation in its quest to level the playing field between gay and straight couples. This strategy, as far as I'm able to determine, is based partly on the premise, a premise that I find totally sound. That premise holds that no minority group should ever have to beseech popular majorities in order to have its fundamental rights respected. As I said, I have no quarrel with this argument, and I find it very convincing. However, that is convincing in the abstract. In the real world, the situation is more complex. That, in my view, is the lesson that must be learned from the Proposition 8 fiasco in California. In that case, as we all know, the California State Supreme Court granted marriage equality, only for that grant to be ultimately thwarted constitutionally by a determined, however narrow, Democratic majority. How was the mighty judiciary fallen? What the Proposition 8 caper should have taught the gay rights movement is a painful but necessary lesson. In a democratic society, even the best written constitutions and even the most vigilant jurists cannot, all by themselves, protect vulnerable minorities from the so-called tyranny of intolerant or hostile majorities. After all, constitutions can be amended. The United States Constitution is no exception. Unlike other democracies such as Germany, for example, the United States does not place any part of its constitution completely beyond the power of democratic majorities to amend. That means that in a case such as this, Congress and the state legislatures could potentially repeal any Supreme Court ruling mandating marriage equality by amending the Constitution. Now, I do not mean to ignore how tall an institutional order such a move would be. Nonetheless, I caution all of you against cavalierly dismissing this possibility. Do not complacently assume that a movement to amend the United States Constitution to define marriage as a union between one man and one woman would necessarily fail. Be aware that in the court of public opinion, this cause still has a ways to go. A great many Americans will recoil from what they will see as the redefinition of marriage for the whole country based on the decisions of a handful of arrogant, unelected judges. In other words, ultimately, even if such a measure fails, it will be because of a political battle that we fight and win in the court of public opinion. Remember, that court seldom, if ever, grants summary judgment. Almost every case goes to trial. In short, democratic constitutions do not render even the most fundamental, inalienable rights completely untouchable. Those rights cannot even survive, let alone thrive, unless they are accompanied by a popular culture of tolerance. That culture is something that can ultimately only be cultivated by the citizenry itself, not by judges or constitutions. That means that we will not be able to perform a judicial end run around most Americans' conservative views of marriage and the family. We must face up to the task that we have ahead of us. We must accept the fact that we have hearts and minds to win, 300 million of them. Not only the hearts and minds of judges, of course. I refer to the hearts and minds of the American people themselves. The Constitution, then, does protect the right of same-sex couples to marry. However, it does not do so on its own. It cannot do so without the toil, perseverance, and vigilance of those in whose name the document was drafted in the first place. We, the people of these United States. Thank you very much.